Yes.
Thank you. Could we have DHSC 0041159_205, please? I want to look at two documents, Ms Flint, before asking you a question, to make sure that we have the chronology in place. This is a document from Gerard Hetherington to Becky Spavin, dated the 26th of May 2006, responding to the email setting out the action points from the meeting. And we see under the heading Documents, both ministers requested that we should give high priority to examining the files which had been returned to the department by Blackett, Hart and Pratt solicitors. While I've reprioritised the work of existing staff in the division, the work required to examine the returned documents, together with several other related tasks, represents a major undertaking. I've urgently requested additional staff from the business partnership team. We've also arranged with Sol to commission an initial analysis of what the returned papers contain, to be carried out by an independent legal expert panel counsel. We will also pursue your suggestion of seeking assistance from the Information Commission. There's then a question about having assurances that the documents are being held securely, and then a note in relation to the documents which have been destroyed. And then under the heading Demand for a Public Inquiry, we see this. Ministers pointed out that demands for a public inquiry were intensifying. MSPH was particularly concerned that this issue should not be forced in England because of decisions in Scotland. We've consulted Dr Aileen Keel, DCMO in Scotland. Advice from Scottish executive officials to Scottish ministers continues to be very strongly against holding a public inquiry. The executive is examining the validity of a vote in the Scottish Parliament Health Committee in support of a public inquiry. It is understood that the casting vote of the chairman may be disallowed. We are consulting the Patient Safety and Investigations branch about the steps that might have to be gone through in considering whether to hold a public inquiry. As ministers will be aware, public inquiries, now governed by the Inquiries Act 2005, are huge undertakings which can be massively expensive and are held only in exceptional circumstances. There's then a discussion of other inquiries not falling short of public inquiries which had been undertaken. It says this was done as a concession to those who'd been pressing for full public inquiries and had sought a judicial review of the department's decision not to hold public inquiries. The then Secretary of State changed the rules to create what became known as a modified form of private inquiry. And then if we can look to DHSC 0041159_204, please. And we see a paper that also came to your private office in very similar terms. But if we turn the page, we see the pros and cons of a public inquiry are set out throughout page 2 and page 3. And then on the final page, which is where I want to pick it up with you, we see this at the top. DH did have the power to conduct an inquiry, such as in Ailing, Neil and Kerr Haslam, which became known as a modified form of private inquiry. Such an inquiry can still be established under Section 2 of the 1977 NHS Act, but the Secretary of State can no longer delegate powers of compulsion to the Chair, as the Inquiries Act 2005 repealed Section 84 of the 1977 Act that created those powers. This could be seen by interested parties as undermining the value. Then there's an indication of suggesting the early release of papers, and then this. On balance, therefore, we consider an inquiry to be disproportionate and not justified in the circumstances. This is in line with the views of the Scottish Minister, and will continue to keep in close touch with officials in the devolved administrations, including Scotland. Just in relation to the idea that there could be some form of inquiry which wasn't a full public inquiry. That was something that you and Lord Warner had raised in your meeting, and this was the response. It might be suggested that it's a relatively limited treatment of options that were open to you. Was that your sense at the time, or was your view this was as much as there could be said?
I think we were opening up a discussion based on a number of different factors that were raising the possibility that we would might have to look at this issue again. And part of that was factored by the documents that were arriving and what they might say or what they might not say that could be important either to keep the status quo policy or to change the policy. So I think some of this was exploratory. I think I say in my statement that this sort of setting out the pros and cons like this wasn't necessarily what we were thinking in terms of that conversation. We possibly might have wanted something which was a bit more about, what would happen if there was information that came to light that contradicted existing information. Should we be having some discussions about that ahead of the cataloguing of the documents and the identification with other documents, or not, as the case may be. So I think this was exploring, and likewise we were exploring other potential options that were independent of the department, that were not the same as a public inquiry, but could provide some other form of validity to a review.
It might be suggested that the officials were not providing you with very many options, and that they were perhaps being reluctant to explore those options. Was that your sense?
Yes.
And why do you think that was?
I think the whole issue of the public inquiry was through the prism that there was no wrongdoing, and that had been an established position for decades, and that every discussion of public inquiry was hinged on that premise. And so I think it was quite, difficult to open up that discussion and talk about, even if there has been no wrongdoing, are there other issues that need to be looked at that alter some of our assumptions and policies, and obviously financial support would have been one of those issues.
And when you're talking about other options, were you thinking of something more than the review of documents that was being undertaken by Linda Page, the internal official?
Yeah, I think on this I think it's on this document or the one before, you'll notice that it's my writing at the top. If you'd like to go back to that page.
I think you mean it's page 1 of this document.
Yeah, I think so. So at the top there, that's my writing where I say, okay. You can make that a bit smaller so I can read it.
It's the blue handwriting that we're looking at.
Yeah. The note to SOS, which is Secretary of State, includes NW's, that's Norman Warner's idea, I think, question mark. And that was an idea that Lord Warner had about having a retired judge or lawyer heading up a sort of, I suppose, independent commentary or review as another option to look at and consider.
And what was your view of the value of doing that?
I thought it was a good idea. I think on another document I said not a bad idea, where it was might have been in a note from Lord Warner's private office. But yeah, I think I wrote not a bad idea.
We can see that. It was the next document
I was going
to take you to. At DHSC 0041159_251. These are Lord Warner's comments on the submission, and we see MSR suggests that the weakness of DH's position is the slowness in collecting, reviewing and publishing documents. MSR also suggests that he would not go as far as to commission a public inquiry, but use the powers under the 1977 Act for the Secretary of State to commission a review of all the documents, new ones, old ones, and if possible, Scottish ones, with a view to producing an independent legal/judicial commentary on them and putting all of these into the public arena. MSR thought that a retired judge stroke QC could do this with an administrative support team with the aim to complete within 6 months. And then we see that handwriting, not a bad idea, and that's your handwriting.
Correct.
You then put a note up to the Secretary of State setting out the background and having a discussion about a public inquiry. If we turn to that, DHSC 0103399_003, please. We see the issue set out, and if we turn the page, there's the heading, Demand for a Public Inquiry. Officials have therefore, on balance, advised that an inquiry would be disproportionate and not justified in the circumstances, in line with the views of the Scottish Minister. As an alternative, we've explored the possibility of commissioning an independent review and commentary on all the papers. With regard to the relevant statutory powers, it then sets out how that would happen, and it says it would provide additional reassurance and information to the public and would build on the steps officials are already taking to review all the existing papers. It would, however, not provide powers to compel witnesses to give evidence or produce documents, and we would need to draw the terms of reference accordingly. Conclusion, you're invited to note the current position and the line we propose to take against the need for an inquiry, and further to consider the option of producing an independent commentary on the papers under the Act. In your conclusion, this submission simply suggests that the Secretary of State consider the option. It doesn't recommend the option. Why is that? Is that a significant difference? And if so, why was there not a recommendation towards it?
Maybe it's just a poor choice of words. I think we were flagging that this could be a good way forward as a proposal, and I think we thought it was one of the a very positive thing to offer, and that's why we put it there. Maybe we should review this recommendation rather than consider. Maybe it's just the wording and drafting of civil servants.
Could we then turn to DHSC 0041306_038, please? We have a handwritten note, I think from Patricia Hewitt, responding to the two questions. If both Norman Warner and Caroline Flint really believe an independent commentary is worth it and affordable, I assume we'll need to pay him/her fine, but I fear it will fuel, not deflect, calls for a public inquiry, which we are absolutely right not to do. What did you understand to be the basis for the Secretary of State's view that the independent review might fuel calls for a public inquiry?
I think that it wouldn't. I think in the view of officials, that it wouldn't be enough, and obviously it had limitations in terms of what it could do in terms of a suggestion. And therefore, it could be an exercise that just, doesn't allay any concerns, and would cost a lot of money and time, and at the end of the day, it wouldn't resolve anything. I suppose that's a fair point of view on one perspective. On the other side of things, our view was that actually maybe it would be helpful and it would allow something to be independent of the department, and particularly because the issue of documentation was so much part of the conversation about confidence and whether the basis of which the decisions made around this issue over these decades were the right ones based on the right information, and therefore I think that's why we were positive about it. She had her own view.
If we then turn to WITN 5427031, please, and turn to page 3. We see this message is from the private office, telling you about what the Secretary of State's view was. And then the second paragraph, Lord Warner's view is that this is really your call, as it's your policy area. He does not think the calls for a public inquiry will go away, whatever we do, but thinks an independent commentary on all the papers available will help to resist a public inquiry. He still thinks the commentary is worth doing if the money is available. And then I think it's your handwriting asking how much would it cost and what length of time would it take.
Yeah.
And then if we turn back a page, we have a note again from your private office indicating that officials estimate the review would cost up to £100,000 and is likely to take several months to complete. Something pointed out that there is no money identified for this. And there's a note from you to make sure that Norman Warner is aware of this and that you'll have a further discussion after the recess. This is the 30th of August. I just wanted to take you to that because I want to come back to it in a moment, but we're there in the 30th of August. In terms of the chronology, in the September of 2006, 47 files were then found in Wellington House. And we have a letter from you, let me rephrase that, a note referring to your views of that. If we could have DHSC 5121353, please. Sorry, sir, my referencing has gone wrong there, but this is the correct document. We can see here an email from Elizabeth Wooderson to William Conan, and in the first paragraph it says one of the things Jackie mentioned was a letter to Lord Jenkin about contaminated blood products files. Apparently Caroline is very worried about this and has agreed with Lord Warner that he should write urgently to Lord Jenkin to clarify whether the 47 files mentioned in the letter were included in the self-sufficiency report. If not, she thinks we are in big trouble. Can you help us with why you were so concerned about this issue?
I think I was pretty annoyed about more documents coming forward, but also in the context of the self-sufficiency report. Obviously the report did acknowledge it wasn't complete, but again my concerns were that here are some more files that we need to go through, and if they were pertinent to the self-sufficiency report and were not included, that would create again more concerns, reasonable concerns from different parties as to the legitimacy, I suppose, of that report and what was being said. And, you know, I didn't know what was in these files. I didn't know what was going to be coming forward, but it just seemed that, you know, there was, you know, one set of files, papers after another in a relatively short period of time coming forward. And I suppose I was just expressing my frustration at all of this and constantly having to sort of obviously find ways to get these documents identified, matched against what documents were referenced in other reports. But it was a challenge, I think, because you always sort of running to catch up and you're trying to assure people, and then more files become available.
So that was October 2006. Would it be fair that at that point in time you had concerns about whether the self-sufficiency report really covered everything adequately?
Obviously, I you know, as I said, the report did say that it wasn't complete, that, you know, it couldn't definitively say that all documents were covered by it, and the reasons for that. But again, this was just, you know, another point in the process where potentially there were more files that would have added to the report, or there would be files that would be already in the report. We just didn't know, and it was that just not knowing, and just, as I say, the more and more discoveries that was disconcerting. It wasn't, I necessarily thought at that point the report was wrong, but obviously there was a risk that it could be, depending on what was in these files, brought into question about what it said and the narrative it gave.
Could we then turn to CBCA 5045 and page 7, please? This is an answer to a question, a parliamentary question dated the 7th of December 2006. The question is what assessment you had made of the merits of undertaking a public inquiry into the supply of contaminated NHS blood products to people with haemophilia in relation to HIV and hepatitis B. And an answer is given described as a holding answer. We regret that patients were infected with HIV and hepatitis B through treatment with plasma products prior to the introduction of heat treatment in the mid-1980s. There's a description of the heat treatments. There is then the line, donor screening for HIV was introduced in 1985 and donor screening for hepatitis B was introduced by 1972. Both these microbiological tests were introduced as soon as practicable. In view of these actions, we do not consider a public inquiry is justified. In February this year, the department published the report on self-sufficiency in blood products in England and Wales, which is available at, and then the webpage. This provides a summary on the issue of infected blood products. I've been asked to ask you about this answer. It could be read as suggesting that a public inquiry wasn't justified. And part of the reason it wasn't justified was because the self-sufficiency report addressed the issues. Is that how the answer was intended to read?
I think there are, within the answer, I think there are a number of reasons given, not just in terms of self-sufficiency report, but before that in terms of what was able to be developed during those times. But clearly the self-sufficiency and whether that was possible or not was a factor in all of this as well.
If there was a lack of certainty in the contents of the self-sufficiency report because there were outstanding documents to review, with the benefit of hindsight, do you think that the line to take that was given in this answer should have been different?
My sort of understanding of parliamentary questions is that actually in answer to the question you answer with what you believe to be known, rather than something that would be, for example, necessarily speculating on what might or might not be. From what I recall, the issue of the 47 files, and we may come back to this later, were then picked up and pulled into the review that was being done internally as well, in relation to non-A, non-B hepatitis, which also was looking at the Scottish documents, also looking at the return documents from solicitors as well. And it was put into that to clarify whether any of those documents were copies of what was already referenced in the self-sufficiency report or were additional documents that it didn't contain. But that was a process that hadn't finished, I think, by this time. The report was next year. Indeed.
And I want to turn to a submission that deals with that. DHSC 0041193_026. It's a submission from Liz Wooderson to yourself and MSQ, dated the 24th of April 2007, dealing with the review of papers dealing with non-A, non-B hepatitis by Linda Page. And we see in the first paragraph that the report concludes that the documents provide no new information that challenges the department's position, and that CMO has commended the report's rigorous analysis and agreed its conclusions. Background is given, and then over the page, the way forward, we recommend that the attached report should now be released to Lords Archer, Morris, Turnberg and Jenkin, the Haemophilia Society and all other interested parties. In addition, we recommend that we should release the documents reviewed in line with freedom of information principles. Overall, there are around 4,500 of these documents, so this will be a major task. It's estimated that the preparation and processing of the documents will take approximately 4 to 5 months. There's a question of cost. Then, nevertheless, we recommend this approach, as release of the documents may go a considerable way to support our line that a public inquiry is not required, as all the information is in the public domain. This includes 58 previously unpublished documents specifically referenced in the current report, which we would treat as a priority. And then paragraph 11 given that this inquiry is going ahead, and that's a reference to the Lord Archer inquiry, we assume you will not want to pursue the option of commissioning an independent review by a QC for the time being. We did not recommend this in our earlier submissions because we estimate that such a review would cost in the region of £200,000. We do not have funds available for this, and we doubt that it would satisfy external parties anyway, as an independent review by a QC would not be able to compel witnesses to give evidence. First of all, that figure of £200,000 is obviously double the figure that was given to you originally. Did you explore why that was?
I don't recall exploring that particular issue. As you said, the Lord Archer review had been initiated, and I think in some respects that sort of overtook sort of events. However, in this submission, it says for the time being it wasn't completely ruled out as a potential for the future.
To what extent were budgetary issues the reason why an independent review wasn't undertaken at this stage?
There is always budgetary issues raised on anything. The internal reviews that Linda Page undertook, there were always issues raised about monies, and the fact that, within the staff that were particularly involved in this area of work, there was the impression I got as a minister was there weren't enough people to cope with the amount of different asks on their time. So it was always a question if there was anything additional over above what they were doing, that would require more money. So that was always an issue in this.
We've seen in a number of documents that there were issues with this particular team not having the resource to do the things that you were flagging. Did you raise that question of resource with those who could deal with that?
So before we got into the summer of 2006, I think we've covered some of those documents earlier today. Lord Warner and I were pressing for more resources and more authority at a senior operational level within the department to tackle these documents. Some of them had, I think, been with us for some while, but there had been not enough staffing and resources to go through them. I think that was the case in terms of the documents found in Scotland. And as a result, we basically we raised the pressure and wanted the CMO and the permanent SEC involved to give their authority to allowing some resources to be provided over and above that the blood policy unit could provide. That was a consequence of that was Linda Page being brought in.
Could we then put up on the screen a paragraph from your witness statement, WITN 5427001, and it's page 143, please. It's a fairly lengthy paragraph, but I will read it out for those who are watching as well. It had been government policy not to hold a public inquiry. Lord Warner and I considered whether that policy should be maintained, and both reached the view that it should. The documents indicate this was supported by the Secretary of State. My recollection is that I did not seek to overturn established government policy and support a public inquiry at this time because of the medical and scientific information I was receiving, which I was informed was compelling. I was informed that the advantages of using factor blood products to treat haemophiliacs outweighed the risks, that accurate screening for hepatitis C was only available in 1991, that even if self-sufficiency had been achieved, hepatitis C infections would still have arisen from blood supplies here, that non-A, non-B hepatitis had been considered a mild disease by the medical and scientific community for many years, and that BPL had developed a heat-treated product in 1985 that had proved safe. I was not being presented with a significant amount of evidence that the medical and scientific community or the governments of the day had disregarded the risks of infection. I am neither a scientist nor a clinician, but I do not recall being told by officials that there was a widespread of medical and scientific views on these kinds of issues. I do not recall the CMO or Deputy CMO expressing concerns to me about the government's position or a view that the government should change the established policy, and then, although I'm happy to review documents if they show that I did. During other hearings, the inquiries discussed the question of groupthink, that in that sense that when you work closely and collectively together, there's a risk of a group mindset developing, particularly in relation to the final part of that paragraph, that you weren't being presented with a significant amount of evidence from the medical and scientific community or the governments of the day, that they disregarded the risks of infection. And officials and weren't saying there was a widespread of views. Did you ever consider whether there might have been an element of groupthink, that there wasn't a historic problem here?
I mean, I was aware that there was like one view in the department. There didn't appear to be any other view than the one that's outlined in my statement here. And I think also that because of what I've outlined here, and therefore coming from that sense that there was no wrongdoing, that was the prism through which everything else was viewed. And so it didn't apply itself, as I think I've said in my statement, to thinking, well, okay, even if you're saying there's no wrongdoing, is there anything more creative we should be doing in terms of our support or in other ways for individuals and communities affected by this? It became a sort of, we can't open that up, which again I don't think necessarily was helpful. And if you're spending time reflecting on this, looking at many documents, and with hindsight to a certain extent, I think that is the case actually.
Sorry, can you just be clear, what was the case?
I think it was the case that actually this one view, and actually in one level I think, I left the department, in all honesty, still thinking that was the case. But even if that was the view and you could back that up, it shut down opportunities to maybe discuss other ways to deal with the many serious issues that individuals and families were facing. In some ways outlined in the McFarlane report in terms of life expectancy, but also what came with that were additional challenges and hardships.
We see the sentence, I don't recall being told by officials that there was a widespread of medical and scientific views on these kinds of issues. Did you ever consider that the clinicians and scientists who were providing that information to the officials might have been the ones making the decisions in the 1980s and early 1990s? So they might have been reluctant to address whether there had been errors.
I don't think I did in that way. As a minister in a department, you look to the civil service, which is independent of politics, for advice and information. And obviously they're the ones who are there. They have the collective memory as ministers come and go. Part of the whole point about the documentation was to make sure that actually the basis on which they were advising on policy was as true and accurate as it could be. But I don't think I did actually necessarily think about that. There were, if I remember rightly, and if I'm wrong, happy to be corrected, one of the issues around the self-sufficiency report was, I think, present clinical opinion also being sought in views of that as well, who I don't think necessarily were the ones who were involved at the time. of the infections taking place. And in fact, it was a clinician who was asked to provide expert view in terms of inquiries from the media because of that very reason.
We saw in an earlier document that the Page report dealing with non-A, non-B was sent to Lord Archer in May 2007. The Archer inquiry was obviously announced in February 2007. And I just want to explore a couple of matters in relation to the Archer inquiry. Lord Archer wrote to the Secretary of State on the 16th of February 2007 asking for someone to be available to say what the department's position has been and is, and to lay before them any further facts which the department felt the inquiry should be aware of. Just for the transcript, that's DHSC 0041193_056. Mr. Conan prepared a draft response and sent it by email, DHSC 5458684, please. At the bottom of the page, as requested, I attach a draft letter for MSPH to send to Lord Archer following his letter to Secretary of State regarding his inquiry. The advice is that we should not become involved in Lord Archer's inquiry at all. The attached draft, which has been cleared by Permsec and Sol, takes a fairly robust line. And then if we turn to DHSC 306752, we have the draft letter. Just two paragraphs I want to highlight. The first one, the government has great sympathy for those infected with hepatitis C, and as I'm sure you're aware, have considered the need for a public inquiry very carefully indeed. However, the government of the day acted in good faith at the time, and therefore we really do not feel that a public inquiry would provide any further benefit to those affected. In fact, actually believe that prolonging this issue may serve to prolong the suffering of those who have been affected. And then the last paragraph, in conclusion, I can only repeat that the government does not support your call for an independent inquiry, and therefore it would not be proper for departmental officials to appear before your inquiry. You then sought a meeting with the Secretary of State to discuss the Department of Health approach to the Archer inquiry, and that meeting took place on the 13th of March 2007. And if we can just look at the notes to that meeting, then I want to ask you a question about it.
Just to say that
course.
letter wasn't sent, even though it's got my name on the bottom.
This was a draft that you were
draft.
sent, and I think it was because of this draft that you sought a meeting with the Secretary of State to address whether this was going to be the approach that was going to be taken. Is that right?
Correct.
WITN 5427017. It's a note of the meeting, I think, between yourself and the Secretary of State. Meeting started with a brief discussion on Lord Archer's inquiry. Secretary of State thought we need to find out more information about the inquiry and asked either MSPH or MSQ to follow up on the terms of reference, etc. On the draft response to Lord Archer's letter, MSPH was concerned about the content and language of the letter. Number 3, Secretary of State gave a steer on how we approach the inquiry. She is happy for officials to give evidence to the inquiry, but only after they've completed and compiled their report on the analysis of the documentation. She's also content to make all the documentation available to the inquiry. In relation to the second point, you were concerned with the content and language of the letter. Can you explain to us why?
I didn't like the tone of it, and I didn't think it was cooperative enough, to Lord Archer's request. And I thought we needed further discussion on what form cooperation should be.
We see the steer given by the Secretary of State. Did you agree with that steer?
Yeah. This was a meeting we had I can't remember it exactly, but we had a good discussion, and one of the issues obviously was about what form cooperation should take, and I came away from that meeting pleased with the outcome.
There were then submissions on the 23rd of March 2007 to Hugh Taylor. There are two sets of submissions, and it's a little bit unclear which is a draft and which is final. And so I'm afraid we will just look at both of them with that caveat. DHSC 5046267, please. And I want to pick it up on page 2, please. There'd been a discussion of the background, and there's an indication that the plans in relation to document review have obviously now been overtaken by the announcement of the Archer inquiry and Minister's natural wish to be helpful. However, there remain a number of questions and concerns amongst the team here regarding departmental involvement in this inquiry, which I'd just like to flag up to you. They mainly arise from the suggestion that officials should agree to appear as witnesses. And then there are 4 points. There's no evidence of any negligence or wrongdoing on the part of the department during the period in question, 1970 to 1985. Nevertheless, given the subsequent destruction and loss of a number of files, there is considerable scope for embarrassment for the department if officials are asked to appear before the inquiry. Secondly, there's a concern about the amount of preparation that would be required. Thirdly, a concern about ministers being asked to give evidence. And then this, we will inevitably be pressed to release documents without any redaction and to release submissions. While none of these policy documents gives rise to any real concerns over liability, some are sensitive in respect of potential for criticism or embarrassment of former ministers and senior officials. It may be much harder to maintain the line that we are only prepared to release documents under FOI principles if officials are asked to defend it publicly in front of the inquiry. In terms of the references here to embarrassment or for the department, were you aware of that as a concern of the officials?
Look, they make the point here, but I think it was already pretty embarrassing how many more documents were being discovered.
And what weight did you give to that as a concern?
Not too much. I think I think there are some points within this note that are problematic. I think in terms of what would be expected, given this wasn't an official public inquiry about the remit of it. What boundaries, if that's the right word, or framework should exist, but that was something maybe to explore with Lord Archer and his team. But obviously it was pretty strong, the pushback.
And then we have the second version of the submission draft final, DHSC 5857854, please, and page 2. And we see a similar list, albeit reworded, and we see towards the bottom an addition. Given the time which has elapsed, it's not clear exactly what evidence officials would be able to provide in person beyond rehearsing the documents which are already in the public domain. There are other differences between the drafts, but that's the sort of main addition. What significance did that hold for you?
Again, I think at this point there hadn't been any real discussion with any other party except internally. So I don't think even at this point, and again, I'm happy to be corrected, I'm not sure at this point we really knew the terms of what the Archer inquiry would be looking at in any real detail. So, yeah, I mean, it's a fair point, but it's in isolation from having that conversation.
You said a moment ago there was pushback from the officials to the original decision that people would give evidence. Were you surprised by that pushback?
Not really.
Were you surprised by the degree of pushback that there was?
No.
We then have a final submission to the Secretary of State and to you. DHSC 004137_142, please. And we see on page 2 a series of bullet points setting out the concerns of officials about giving evidence. And on page 3, we have the heading recommendation. For all these reasons, we think it's not advisable to offer in the reply that officials would be willing to give evidence to the inquiry. The offer of a meeting between Lord Archer's team and departmental officials is qualified to explaining about our review and the level of assistance we can provide his team. In terms of the meeting with Lord Archer, this submission suggests that it was going to be a relatively limited meeting to simply explaining the review and the level of assistance that could be provided. Again, did that surprise you that that was all that was going to be offered?
No, it didn't surprise me. I mean, we had gone from the start of this and not having any contact whatsoever. So on one level, it was more than was initially suggested. But yeah, it didn't surprise me given the context of not giving evidence that whatever meeting had would be limited in different respects.
It's quite a shift, or it might be suggested that it's quite a shift from people giving evidence to a meeting only to explain the review and the level of assistance. Did you agree with that shift?
I think I came out of the meeting that we had with a direction of travel that I was happy with. You've shown different documents that shows the arguments against that. Some of them I understood, and understood that some elements of this would be problematic for officials. But it became very clear, and if you go back to the previous page, that by this point, senior officials, the permanent sec, and the Secretary of State were of the view that we shouldn't be enabling officials to give evidence. So I didn't really think there was much more I could do. We'd got a meeting with the team, and I think that was the best I thought we could get.
And the letter went out to Lord Archer indicating that the inquiry, I think, has looked at previously. The reference is DHSC 0041193_048, just for the transcript. On the 25th of April 2007, departmental officials met with Lord Archer. That wasn't a meeting that you attended?
No.
But you were provided with a briefing note on it in order to answer a parliamentary question. Sorry. Yes, WITN 5427. WITN 5427033, please. And if we can turn to page 2. We have a question that's been asked about the assistance that it was anticipated that the department would give to the Archer inquiry, and a suggested reply. And then if we go over the page, we have the briefing note that went with it. MSPH will be aware that officials met with members of the inquiry team on the 25th of April 2007. The meeting went well, and officials agreed to follow up some queries that the inquiry team had. It was agreed to provide a chronology of events, which we are currently working on, and a copy of the report, Review of Documentation Relating to the Safety of Blood Products, 1970 to 1985, and the supporting references. MSPH has agreed that we should proceed with making copies of all the documents we hold on blood safety for the period covered by the internal review, available in line with the Freedom of Information Act. It will take several months to complete this work. When you received this briefing and were due to answer the parliamentary question, did you ask officials whether these documents were all that the Archer inquiry was seeking from the department?
I can't remember.
And was any thought given to whether other documentation or other assistance should be provided?
I can't recall. I think if there had been requests coming from Lord Archer's team, then I would have presumably wouldn't have been made aware of it in one form or another if it needed ministerial sanction. But I can't recall that happening, and not long after, a couple of months after, I moved to another department, and there were 2 further meetings, I think, under another minister.
Do you recall at the time having any concerns about the degree of cooperation that officials were having with the inquiry?
Well, obviously, I was concerned from the initial suggestion that there was a reluctance to cooperate, but at this point there were no, if you like, complaints coming back to me via, you know, Lord Archer or anyone about this meeting, and therefore it didn't raise any flags with me at that point.
Could I just put up on screen the final paragraph of your witness statement at WITN 5427001, please? Paragraph 3.312, which is on page 193. And you say this: I think government probably should have established a UK-wide public inquiry before it did, but that decisions, including during my time, were coloured by Department of Health's position that there had been no wrongdoing. In preparing this statement, I've reflected that things would have been different if DH could have worked better with campaigners, the financial support schemes and others to find better solutions for those infected and their families and look into lessons learnt without the DH focus on wrongdoing or liability. Can you tell us a little bit more about what you think should have been done differently?
I think it could have been explored whether there were other ways. I'm not a lawyer, so forgive me if I don't use the correct language here, but something where there was a suggestion of no fault within it. I know some campaigners and others wouldn't have wanted that. But you could have created the environment where we could have dealt with some of the very real and practical issues people were facing, and some issues around the health service dealt with people. I mean, in this case, not only people who, in terms of a condition they had in terms of haemophilia, but also what was then caused by HIV and hepatitis C, and of course to the families. And maybe there would have been a better way to do that. And, you know, there were potentially examples of ways in which that could be done that I don't think necessarily were explored, but everything was seen, and I think I said this, through this prism of wrongdoing, which I think didn't help with the creativity on that. I think there's another thing as well about government and departments, whether or not, I don't think this is in my statement, but whether or not on something like this, there's almost, for want of a better phrase, some sort of peer review by another part of Whitehall, whether that's the Cabinet Office or elsewhere, or a particular unit set up to look at these things, where obviously this has been a continuing concern for justifiable reasons that hasn't necessarily been resolved in the time it probably should have done.
So those are the questions I have for Ms Flint. We obviously need some time for core participants to provide any further questions.
Yes.
I wonder whether we might take our afternoon break somewhat early to enable that process.
Well, of course. We have to take a break in any event, have we not? So we may as well take it now. Let me explain. Those core participants in this inquiry who are represented by legal representatives have a right through those representatives to put questions for you to answer. Those questions will have arisen not only by reading your statement, but by listening to what you've said today. And since you only just finished saying it, they have to be given time to formulate any questions they may have. I don't know how many questions there'll be. There may be very few, there may be quite a lot. But we have to give time for them to be fielded by counsel. And it coincides with the opportunity to have a cup of tea and a break. So we won't meet again until at least 3:30. I'll say not before 3:30, just to give extra time, should it be needed by council. If that's going to be the case, you will be told. But I look forward to seeing you not before 3:30 for that final round of questions.
Thank you.